Hello, everyone, and welcome to today's Friends Life Care Wellness webinar on estate and Medicaid planning, presented by estate attorney Nego Pile. My name is Gail Tamarchio. I'm the Friends Life Care Director of Wellness Initiatives, and I'm delighted that you are joining us today. I'll be your moderator for today's session, and will be Hello, everyone, and welcome to today's Friends Life Care Wellness webinar on estate and Medicaid planning, presented by estate attorney Nego Pile. My name is Gail Tamarchio, and I'm the Friends Life Care Director of Wellness Initiatives, and I'm delighted that you're joining us today. I'll be your moderator for today's session and will be providing some housekeeping information before we start to ensure that you know how to participate in today's event. Here's a screenshot that shows an example of the attendee interface. You should see something that looks like this on your own screen in the upper right corner. You're listening in using your computer or tablet speaker system by default. If you would prefer to join over the phone, just select telephone in the audio pane and the dial-in information will be displayed. You'll see it there next to the right of the orange arrow. Now, you'll also have the opportunity to submit questions and comments during the presentation by typing into the questions pane of the attendee interface. You see that in the big box, the second red box below there. And we encourage you to ask questions. We'd love to hear from you. However, if you have specific questions for Nego, please type them into the question box and he'll answer you privately later. We're looking for questions for the webinar that will be of a general nature. And Nego may ask you to participate today by raising your hand. To do so, click on the yellow hand directly to the left of the question box. So directly to the left. And please send any questions or comments at any time during the presentation. Nego will be able to respond to some questions during the presentation and he'll answer others at the end. So now I would like to introduce our presenter, Nego Pile. Nego is an attorney with the Pile Law Firm and practices in the areas of elder law, estate planning and administration, guardianship, special needs planning, business law, and real estate. Nego is also responsible for all guardianship cases with Intervention Associates, a nonprofit sister company of Friends Life Care, which provides care management and guardianship services. So, Nego, you have a very eager audience to hear what you have to say today. Thank you. Welcome.
Wonderful. Thank you, Gail. Can everyone, well, if anyone is unable to hear me, just type that into your interface or raise your hand. It's my pleasure to be here today. And as Gail said, I practice in the area of elder law, and I do estate planning as well as Medicaid planning. And I also work with Intervention Associates on their guardianship cases, handling all matters pertaining to guardianship, power of attorney, and those aspects. So we will start the presentation. Estate planning. The primary function of an estate plan is obviously to create peace of mind for not only the individual that's drafting or creating the estate plan, but for their family as well. It allows you to maintain control over your decisions and also your assets. One of the most important things that you want to do in an estate plan, and I always tell my clients, is you want to leave a legacy. And a legacy is something more than just leaving property or assets. A legacy is those values that are important to you and your family, whether it be religious, cultural, or personal to your family. And those are things that you can leave behind, whether video or audio, or combination of the two. And that's one of the most important functions of drafting your estate plan. With regard to your assets, you want to be able to identify or reduce and eliminate estate taxes. You want to also protect your assets from creditors. And if you have a special needs family member, child, or other family member that you want to provide for, you can do that in your estate plan. And also, importantly, you want to avoid probate, and in some situations, that is the goal for individuals. What makes a good estate plan? It's well thought out, so you don't just wake up today in the morning and say, I want to create my estate plan. You want to think about what you want to do in your estate plan. Who are the beneficiaries? What are your assets? What is your legacy? These are things you want to think about. You want to make sure that it's comprehensive as well. You don't want to forget something or to limit yourself in any way. So it's good to talk with your family members. If you have a spouse, talk with your spouse. If you have an attorney, talk with your attorney about it. And in totality, your estate plan should achieve your goals and objectives during your lifetime, which means while you're alive, and also after you have passed on, after your death. Consequences of poor or no planning. Some of the obvious are your medical wishes may not be carried out because part of your estate plan is drafting a living will, a healthcare power of attorney. And these are documents that will make sure that your wishes, your medical wishes, are honored, or that someone will be there to advocate on your behalf for your medical wishes. And if you don't draft your estate plan or create one, guess who's going to make the decisions for you? The state. The state and the courts will determine who receives their assets and in what proportions. That goes back to the whole earlier discussion where we talked about having control over your assets. If you have minor children, your courts will be the body that will determine and decide who raises your minor children if you don't have a guardian in place or nominate someone to be that guardian. Same thing for a special needs child. And your heirs, your beneficiaries, may unnecessarily incur inheritance or estate taxes, things that you could have planned for early on and allow them to receive more assets rather than paying the government with those assets. So the documents in your estate plan, some of the documents will include your last will and testament, a trust. There are various trusts that you can create depending on your circumstance, a durable power of attorney, a living will and healthcare power of attorney. And for people that own businesses, you can establish a business succession plan. And as the individuals age, you can also arrange for a caretaker agreement. That's someone that will take care of you when your activities of daily living start to decline. And you can appoint that person to be your caretaker. That can include a family member. We will discuss these documents as we proceed in the discussion today. The will. The last will and testament is the document where you decide who is going to get your assets. You also identify your beneficiaries. You identify your assets, whether it's financial, tangible, artwork, anything of the sort, as well as this is a place where you can dictate what legacy you want to leave behind. So in order to draft a legal will, you have to be 18 years or older, be of sound mind, and you cannot be under any undue influence. So when I meet with my clients, I meet with the person that's creating the will privately. I don't meet with them and their children and other people at the same time. I can meet with the children and other family members separately. But I want to make sure that that person, and any attorney that you go to, that attorney should make sure that that person is that's creating the will is the person that's speaking to the attorney privately one-on-one, so as to avoid any undue influence. So sometimes you'll have the child in a room and they're whispering to mom, don't forget, you said you were going to leave me $100,000. You don't want that to happen. So, then the parent is, saying, oh, wow, yeah, I want to leave $100,000 to my child. That discussion has to happen one-on-one. And the individual that's creating the will, they're making a declaration. Declaration stating that they are aware of the assets in their estate. They understand who the beneficiaries are. They understand where they are. If it's present day, they understand it's 2017. They recognize that the president is Donald Trump, and they recognize the month. They recognize that, where they are. If they're at their home, if they're at the attorney's office, they recognize those things. And when they execute their will after it's drafted by the attorney, they will also sign a declaration to the effect that everything in the will is their desire and their wishes. They will sign and date it, and there will be two impartial witnesses, meaning people that are not beneficiaries under the will. And you will also want to have a notary notarize your document. So as I said, the will controls the distribution of personal property, such as jewelry, family heirlooms, and other assets. It does not control what passes by beneficiary designation. So that's like life insurance, IRAs, retirement plans where you nominate a beneficiary. You don't have to make provisions for those documents in your will because you've already defined and established who the beneficiaries are when you nominated those beneficiaries in your life insurance, for instance. If you say in your life insurance you want your children to be a beneficiary, the life insurance will automatically, the assets in the life insurance and the proceeds will be distributed to your children upon your death. And the will does not prevent probate. We'll talk about probate a little bit later on, but one of the things about the will is that it becomes a public document at your death. So when your executor or executrix goes to the courthouse to file your will with the Register of Wills, that document becomes a public document that everyone under the sun and on the earth is able to see if they go to the Register of Wills. The probate process is the judicial process in which you pay bills, transfer assets, and so forth. One of the first things you will do in the probate process, not you, the person who created the will, but the executor or executrix, they will file a petition with the Register of Wills, and the will be filed with the Register of Wills as well. And that formal process will get the executor or executrix appointed legally to handle your estate. The executor or executrix will then have to advertise the grant of letters. And the letters of, in the case of a will, it will be letters of testamentary. That's what the executor or executrix will receive when they file a petition. And that letter of testamentary and analogous document that goes with the letters of testamentary is called a short certificate. Those documents will give the executor or executrix legal power to act on your behalf. So when they go to the bank and move money around into an estate account, they will have that authority and the bank will request those documents. The executor or executrix will also have to notify your beneficiaries of your debt. They will also have to file an inventory and a status report with the Register of Wills. And the inventory and status reports can be complicated, and that's where you may want to seek the help of an attorney to kind of help you with that administration process, the probate process. The executor or executrix will also have to prepare and file an inheritance return with Pennsylvania. If the person that died is a Pennsylvania resident, you will have to file an inheritance return with Pennsylvania. The decedent's final personal income tax return will also have to be filed. So if a person passed away in 2016, that final return would have had to have been filed by April 18th of this year. And if you run into any issues, you can always file for an extension. And to wrap everything up with the Register of Wills, you'll have to prepare a final accounting of the estate. And again, this is where an attorney can help you with doing that accounting. It can be an informal accounting where it's just agreed upon between the family, or it can be a more formal accounting where you have to file it with the orphans court and seek approval. Grounds for a will contest. So remember all the discussions we had earlier about what makes a valid will. So some of the things that happen and what I've seen in will contests, it's usually one of these four. It's lack of testamentary capacity. The person who created the will didn't have the proper capacity. They may have been suffering from Alzheimer's, dementia, or some other mental incapacity, or something that may have rendered them unable to appreciate their estate or to appreciate who their beneficiaries are or where their surroundings are. Or it may be undue influence. If there was another person in the room when that person was drafting the will, and again, shouting out to the individual drafting the will, don't forget to leave me that $100,000 that you promised me. That can be considered undue influence. Fraud. Some caretakers, they have the ear of the individual that's taken care of. And they may try to influence, they may try to sign on behalf of that individual in terms of what that individual is going to leave that caretaker or other person. So if that person is signing that person's name, if they are doctoring a will that person previously drafted for their benefit, that's considered fraud. And if the document was improperly executed, so if you didn't have the proper witnesses, if the person drafting the will did not declare with their signature that they drafted this will and that everything in the will is by their wishes, that could be improper execution, and that can be grounds for a will contest. Trust. Trust holds property for the benefit of the grantor, the creator of the trust, or his or her heirs. Think of a shoebox, and you're putting everything into that shoebox, all of your valuables. That's the function that a trust serves. A living trust is a document that is revocable, and it allows you to make distributions during your lifetime while you're alive. And it's spelled out, it's actually created, and it's funded by your asset. Testamentary trust is one that you designate in your will. So in your will, you may say, upon my death, I wish to establish the Jane Doe Trust for the benefit of Jane Doe's heirs. And that trust has not been created. It will be created upon your death. Now, what you have to remember, one of the things we said, we talked about with a will, When you die and your will is filed with the Register of Wills, that becomes a public document and everyone gets to see it. So with a testamentary trust, if you establish a testamentary trust in your will, someone will see that you have created or wish to create a testamentary trust. That doesn't mean that they will see what's in the trust. So the trust will have to be created by your executor or executrix based upon your wishes. The trustee manages your assets in the trust, much like the executor or executrix would in a will. The trustee makes sure the terms of the trust are followed. The trust holds property for the benefit of the grantor. The living trust is an alternative to a will. It takes effect upon signing, and remember, it's effective while you are still living. We have a question. Does everyone need a trust? No, not everyone needs a trust. A trust is beneficial if you have minor or disabled child, or a disabled beneficiary, or a minor beneficiary that you want to provide for. Or if you want to do reduction or minimize your estate taxes, or if you want to avoid probate. That's who a living trust or a trust would be beneficial for. Other individuals that may have a small estate and may not want some of the provisions that I just mentioned will opt to do a will. So going back to the living trust, it takes effect upon signing. Assets are transferred into and retitled in the name of the trust. So you have to fund the trust. You can't just create this document without funding it. If you fail to fund it, the trust will fail, meaning that you have to put, if it's a house that you're putting into the trust, that house has to be retitled in the name of the trust. If you're putting assets into the trust, same situation. It has to be retitled in the name of the trust and taken out of your name. Successor trustee acts when you are disabled or when you die. So when I draft a trust, the individual that I'm drafting the trust for, they're called testators. They often remain as the trustee, and then we appoint a successor trustee to take their place if they become incapacitated or they die. And that successor trustee will perform all the functions identified and the responsibilities identified in the trust. The trust will allow you to avoid probate and reduce taxes. That's something that the attorney would have to specifically establish in that trust, those provisions. Your assets will be distributed, can be distributed at death, but remember, with the living trust, you can make distributions while you are living. And most importantly, the living trust is private. So at your death, the living trust does not have to be filed with the Register of Wills. What will be filed is called a pour-over will. And that is basically saying that literally all the assets in your estate pours into your trust, and that pour-over will is the document that will be filed with the Register of Wills. It doesn't spell out anything specific or identifies your assets or what you have in your estate, and it does not identify your beneficiaries. That's all done within the trust itself. The durable power of attorney typically is a document you will file or create for your handling of your finances, banking, real estate, those things. You want to identify a trusted person to represent you because this person will be signing documents on your behalf. The durable power of attorney for finances will take can take effect immediately, or it can be what's called a springing power of attorney, which becomes effective upon your incapacity. Now, if you do a springing power of attorney, one that becomes effective upon your incapacity, you have to have a doctor to acknowledge that you have the incapacity, so that when your agent under your power of attorney wants to act, can cite the particular doctor's evaluation that you have been determined incapacitated. And the power of attorney ceases to be effective upon your death. At your death, your will or trust becomes effective, and the individual you appoint in those documents will act on your behalf. Now, the word durable means that the power of attorney will be effective even through your incapacity. And that's important because if it's not durable, if you become incapacitated, that power of attorney will not be effective. The advance directive consists of your living will and your healthcare power of attorney. The living will is what you use to communicate your wishes for medical intervention, medical care, when you are no longer able to communicate your wishes to your doctor. So, for instance, it will talk about whether you want to remain on life support or if you want tube feeding. And it's also a good idea to also establish a power of attorney, a healthcare power of attorney, appointing an agent to act on your behalf, because if there's any confusion with your living will, the agent under your healthcare power of attorney will communicate your wishes to your doctors, because you and that agent have been talking well before your incapacity develops. So again, you want to make sure it's a trusted person that's going to make your healthcare decisions when you're not able to. That concludes the estate planning portion. I'm going to talk a little bit about Medicaid and long-term care planning. What is long-term care? Long-term care is the ongoing services and supports that are provided to you because of chronic health condition or some disability that you're suffering. 3 levels of care are involved with long-term care. You can get skilled care, which is the highest level of care that you can receive, intermediate, and personal care. Care can be provided in a variety of settings. You can get your long-term care either at your home, or you can get it in a nursing home. And in terms of who needs long-term care, it ranges from individuals with functional ability all the way to a chronic diagnosis, a permanent or indefinite period, for a permanent or indefinite period of time. So your activities of daily living has declined considerably. You may also be suffering from some level of incapacity, probably some dementia, minor all the way up to severe. And that's where the more chronic cases would come into play. So again, you can receive long-term care at home, an assisted living facility, an adult daycare center, or in a nursing home. Now the million-dollar question: how will you pay for long-term nursing home care? There are various ways that you can pay for it. You can pay for it out of your pocket, which I don't advise. The average cost of nursing home care and skilled nursing home care in Pennsylvania is right around the $9,000 a month mark. You may have some that are less than that, and you have some that are greater than that. So $9,000 a month multiplied by 12, if my math is correct, it'll take you to $108,000. So that's $108,000 a year. some people may be able to fund that, but I think with proper planning ahead of time, you can avoid paying out of pocket. Now with Medicare, Medicare Part A pays skilled nursing care. From day 1 to day 20, it covers 100%. And what happens in Medicare, typically, you're coming from a hospital, some hospital intervention, you may have fallen, broken a hip, and you may be in the hospital for 3 days, and then they send you to a nursing facility for rehab. And that's where the Medicare Part A will kick in. For that first 20 days, it'll pay 100% of your care. Day 21 to 100, Medicare will pay all expenses except the patient copay. And if you're in there for longer than 100 days, Medicare will not pay after that 100 days. That's where you will have to, if you have additional insurance, or you may have to pay privately. And then Medicaid, in Pennsylvania it's called medical assistance. In a skilled nursing home care facility, your stay can be paid by Medicaid if you have no resources to pay for your long-term care costs. And if you plan ahead, your long-term care insurance can pay for your long-term care stay. And basically, your long-term care insurance will have provisions such as the number of activities of daily living that you are no longer performing, how long you've been in the nursing home, and you may have a plan that may pay out for 3 years, 5 years, 7 years, so it's important to really understand your plan. Because some of the long-term care planning that we can do, we can factor in your long-term care insurance along with some other legal procedures that we can take so that you're not spending down all of your assets. And then, you know, similar to a long-term care insurance is a Friends Life Care plan. It's something that Friends Life Care offers. And I'm not going to get into all of the details with Friends Life Care plan, but I provided the web address that you can go to that website and understand more about the Friends Life Care plan. Primarily, the goal of the Friends Life Care plan is to provide long-term care coverage for the individual at their home to the extent that they can stay at their home. And when they no longer can stay at their home, the individual can go on a nursing home. And the Friends Life Care plan will pay a portion of that nursing home care cost. So I see I have a question here. All right, that was not a question. I will continue. Paying for long-term care. Medicaid, using Medicaid to pay for long-term care. Medicaid is a joint federal and state program that pays for the individual's long-term care expenses. Medicaid is a means-based program, so basically the government will look at your assets to determine whether you are you qualify for Medicaid. They will also look at your income to determine where you fall within the Medicaid program. Medicaid, one of the things about Medicaid is limits where you can receive care. So if you are not in a long-term care facility and you're looking to get into one, Medicaid will limit where you can gain access to a long-term care facility. And long-term care facilities are a little bit more ambivalent to having you apply through Medicaid because they're getting less payment than they would than if you were on private care. If you plan ahead, you can actually get into a private pay facility and work on a spend down scenario that will allow you to eventually use Medicaid at that facility. And these can be some of the better rated facilities. And once you are on skilled care, that nursing facility cannot kick you out. You just have to make sure that you proceed with your Medicaid filing. If you fail to file for Medicaid, then the facility can go after you or your children or your spouse for the money that's owed. So speaking with an attorney about this is important. So part of the eligibility for Medicaid with financial resources that we talked about, it will either be that you can retain $2,400 or you can retain $8,000 depending on your monthly income. And your monthly income for Medicaid, if you're making more than $2,205, you would have to be limited to the $2,400. If you make less than $2,205, you're permitted to keep $8,000 of assets, meaning cash, that you can keep for your period. And that's each month. You don't want your assets to go above your financial resources that you're permitted to keep by Medicaid. So Medicaid, the state will look at your cash, your stock, your bonds, bank accounts, your IRA, real estate that you own. The real estate, if it's not jointly held, and if it's not your primary residence, they will look at your real estate for ways of paying for your Medicaid coverage. So all of these things, you can do a spend down, but the spend down period has to be that within 5 years or 60 months of spending down your asset, you have to make sure within that 60-month time frame you're not utilizing Medicaid. If you are going to utilize Medicaid, you want to make sure you do that spend down outside of that 60-month look-back period. And that 60-month period, just to speak on it a little bit more, the government will look back. When you go into a facility, a long-term care facility, they will require 5 years of your bank accounts and financial records. And so they will want to see how you spent your money. And if they see that you gave money away to family members, if you spent money in ways that was to avoid having to pay for long-term care, they can require that that amount of money that you spent be held or be paid to the long-term care facility. So if within that 60-month time period you gave away $30,000 to your daughter, Medicaid can say that that $30,000 has to be paid to the facility, and you will be disqualified from Medicaid until that money is paid to the facility. So this is where the long-term care planning with an attorney can help. Some exempt resources include you can purchase a motor vehicle. So the motor vehicle that you have is 20 years old, it's a clunker, it's not getting around, and you know your spouse or your child needs that motor vehicle to come and see you or come and provide additional care for you at the facility. Medicaid allows you to purchase or upgrade one motor vehicle. Now, you can't go from a $5,000 car to a Maserati. They won't allow that. But obviously, if you go from a $5,000 car that's been around for 20 years and you buy a reasonable car within a $20,000, $30,000 price range, that's acceptable. If you need to do some house repairs, if the primary house you need to repair the roof or do some repairs, those are items that you can pay for, and Medicaid will not ask for that money to be paid to the long-term care facility. Personal belongings. So if you purchase items for your personal belongings, items that you need for clothing and so forth, they will be exempt. A burial plot, marker, prepaid funeral, or an irrevocable burial account are exempt expenses that you can pay. And each county in Pennsylvania has a limit on the burial reserve. So, for instance, for 2017 in Montgomery County, you can spend up to $15,625 on your prepaid burial funds. Other counties, it's less, but you have to make sure that you stay within those limits. Life insurance with a face value of $1,500 or less are exempt, or if the face value is greater than $1,500, then up to $1,000 of the cash value can be exempt. Your primary home, and in your Medicaid application, you always want to check the box that you intend to return home, even if it's unlikely that you will return home, because that little check up of that box will secure your house and prevent your home from being valued as a resource. And also, if you have a spouse or a dependent child still living in the house, you can have that house exempt. The spouse, if you have a spouse that's still living in the community, living in the house, the spouse at home can keep a portion of the resources which are exempt for determining Medicaid eligibility. Typically, the individual spouse at home can keep one half of the couple's total non-exempt resources. And it ranges from a minimum of $24,180 to no more than $120,900. So if you have $240,000 of non-exempt resources at home, the community spouse can keep $120,000 of that. If you have $300,000, then the maximum they can keep is $120,900, and then you would have to spend down the remaining balance. I provided an example for you. Mr. and Mrs. Jones have countable assets of $250,000. Mr. Jones enters a nursing home and applies for Medicaid. Mr. Jones' income is $1,900 per month. And so remember, his income is below the $2,205, so he's permitted to keep $8,000 in resources. Mrs. Jones may keep $120,900, which is the maximum, and $121,100 will have to be spent down before Mr. Jones will be eligible for Medicaid. Some of the ways that you can spend down the $121,000, if you remember from before, you can do the prepaid burial. You can also purchase an annuity for the benefit of Mrs. Jones that pays her a certain amount of money, and also an annuity for Mr. Jones that pays him a certain amount of money. But this annuity has to be Medicaid approved. It cannot be just any annuity. It's a specific annuity that permits Medicaid coverage and allows the community spouse and the spouse in the institution to receive payments, monthly payments. So we have a question: how does one decide whether to have a living trust or a testamentary trust? That is based on your assets and the goals that you want. If you want to distribute your assets while you're living, you will establish a living trust. If you want your assets to be paid at your death, then you'll establish the testamentary trust. Some of the exceptions to transfer penalties that Medicaid would observe: if you make a transfer to a spouse or a minor or disabled child, that transfer is exempt from Medicaid, which means that Medicaid will not ask you to pay that money to the nursing home, even if it's done within the 60-month look-back period. Transfer of your house to a spouse, transfer exclusively for purpose other than to qualify for Medicaid. So if you're making a payment to someone to help them with their marriage, so your niece got married, you gave her $20,000, that's an identified purpose other than to qualify for Medicaid. So Medicaid will look past that and will not ask you to pay that money back to the nursing home. So using a trust in Medicaid planning, you can use either an irrevocable or revocable trust. Irrevocable means that you don't have any opportunity to terminate that trust, and typically you want to have that trust established well before the 60-month look-back period. A revocable trust will not afford you the exemption or the benefits of preserving your assets. With a revocable trust, Medicaid will ask you to pay those assets to the nursing home. A disability trust or special needs trust established for a disabled person will also allow you exemption from Medicaid payback. Treatment of annuities. The annuity must disclose interests of the individual or the community spouse. It must be irrevocable and non-assignable. It must be actuarially sound, which means based on your age, there is a certain amount that you can take out in an annuity. So there is an IRS table that has to be followed. It must provide for payments in equal amounts. So the payouts during each month has to be the same. It cannot differ from month to month. And it also must name the Commonwealth of Pennsylvania as the remainder beneficiary. Otherwise, it will not be a Medicaid-approved annuity. Generally, all of your income, but not your spouse's income, is counted for Medicaid. You can make provisions to, if your community spouse is earning less than you are, to make provisions to allot a portion of your income to support the community spouse, the spouse that's living in the house. And there is a calculation for that. There's also a provision that allows you to keep $45 a month for personal expenses. I want to thank you for attending the seminar. If there are any questions. So the question is whether Medicaid limitations are adjusted annually. It does. Each year, the spousal amount that you're able to contribute varies, as well as the resource limit. That's the amount that you're able, based on your income, that you're able to keep, whether it's $2,400 or $8,000 a month. All of those limits change from year to year. So it's important that you speak with a professional about those limits, because the limits that I talk about in this presentation will not apply next year. So it can be to your benefit next year, or it may be, the opposite. My contact information is on the last slide, and I believe that there will be some handouts distributed to individuals. So if you have any questions afterwards, you can contact me. And one thing I forgot to put on there was my email address. I will give you my email address for both. Intervention Associates, it's N, as in my first initial, Pile, as in my last name, at FLC Partners, FLC Partners, with an S at the end, .org. So that's npile at flcpartners.org. Well, my email address is my name, Nego, N-E-G-O, at pilelaw.com. And you have my phone number out there. So if you have any questions, feel free to follow up.
Thank you very much, Nego. That was a lot of really important information. I'm sure that got a lot of people thinking today about what they need to do next. And thank you, everyone, for attending today's webinar on estate and Medicaid planning. As Nego said, the handout of his PowerPoint is available on your screen. If you look at the handout section of the attendee interface, it's right below the question box. You can download the PowerPoint. If you have any problem, you can email me at Marcio, T as in Tom, O, M as in Mary, A, R, C as in Charlie, HIO at flcpartners.org, and I'll be happy to send it to you. So once you leave today's webinar, you will receive a survey, and we would really appreciate it if you could provide your feedback so we can continue to improve in the future as we bring more wellness webinars your way. You'll also receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar. So you can view the webinar again, or if you'd like, feel free to share it with anyone else you please. Thank you very much for attending, and have a wonderful day.